Thanks for joining our Legal Talk series on Australia's Competition Laws 2021, a year in review. I'm Julia. Today I'm joined with my colleague Jennifer Bannan, Senior Legal Writer for Practical Guidance Competition. Jennifer is a competition law specialist, having worked in private practice at Allens Linklaters and in-house for Johnson & Johnson Medical in Sydney, as well as for Sky TV in the competition and regulatory team in the UK. So Jen, what's 2021 looked like so far in the competition law space? The ACCC has been very active as usual.
Thanks, Julia. And yes, absolutely. The ACCC is known for being a strong and powerful regulator who's not afraid to tackle global competition law issues against big and powerful companies. Under the stewardship of the current chairman, Rod Sims, who's the ACCC's longest serving chairperson, the ACCC has really set its mark as a global thought leader on competition law. 2021 has seen a few firsts in competition law, including the first contested criminal cartel case heard by jury in the case of Country Care, and the first contested judgment under the amended misuse of market power provisions in the case of New South Wales Port. We're also seeing some other interesting private competition law cases move through the court system in Australia and globally, including the interesting cases of Epic and Apple and Epic and Google. Of course, all of this is happening while the ACCC continues to pursue its enforcement priorities, conduct market studies and price inquiries, as well as review mergers and approve authorisations. And the ACCC also continues to advocate for reform, as we've seen recently, as late as August, when Sims proposed significant changes to Australia's merger control regime.
There's obviously a lot going. How does the ACCC work out which issues to focus on and how to divide its limited time and resources?
Yes, so the ACCC decides how to spend its time based on, amongst other things, where it sees the most harm. And it's selective in the matters it investigates and the sectors it analyses, and it accepts that it can't pursue all matters that come to its attention. So the ACCC says that its role is to focus on those circumstances that will have or have the potential to impact vulnerable consumers, that harm the competitive process, or result in widespread consumer or small business detriment. And it exercises its discretion to direct resources to matters that provide the greatest overall benefit. Of course, the agency also receives specific mandates from the Commonwealth Government from time to time, requiring it to review competition and or consumer issues in particular industries. So we have, for example, seen this with digital platforms, the dairy industry, and retail electricity prices. So as part of our 2021 year in review, which given it's early September when we're recording this is admittedly not yet over, it seems useful to start at the beginning. And one of the first items on the competition law calendar each year is the delivery of the ACCC's enforcement priorities, which are announced in February. And this year, the ACCC stated that its competition law enforcement priorities would include reviewing potential competition law issues in the domestic air travel, funeral services, digital platforms, essential services, financial services, commercial construction and agriculture, as well as continuingly actively pursuing criminal cartel prosecutions in relation to the alleged shipping cartel, the CFMEU prosecution, the Country Care case, Vina Money and the banking cartels, as well as a civil cartel case against BlueScope. The ACCC said it would also continue with its competition enforcement work in relation to New South Wales Ports under Section 46, the Peters Ice Cream exclusive dealing case, and also the first case under the revised Section 46 against Tasmanian Ports Corp, which resulted in judgment being entered into by consent.
I see. What has the pandemic meant for companies from a competition law perspective, and how has it impacted the ACCC this year?
Well, for many companies, COVID has meant they've had to shift or pivot their business online or change their work practices. And in terms of competition law, now more than ever, the practices of businesses online are being scrutinised. Of course, some sectors are faring better than others and some are struggling. And unfortunately, many big and small businesses have failed as a result of this change in social health and economic conditions. In terms of the ACCC's workflow, it has not only had to shift its focus to some of these sectors that are most affected by the pandemic, such as airlines and groceries and healthcare, it's also had to review a large number of authorisations from companies seeking to collaborate in relation to activities that might normally be anti-competitive, but that during the pandemic can result in a net public benefit. So the ACCC has, for example, granted authorisations allowing supermarkets to coordinate activities to ensure that they are COVID safe, and for medical equipment manufacturers to coordinate the supply and manufacture of equipment. Overall, however, COVID has not materially affected the function of the ACCC, although it did create a heavy focus on consumers impacted in certain industries, such as travel and groceries and healthcare. And while the ACCC may have allowed some leniency in relation to conduct initially, it soon reverted to business as usual, and this has been the case in 2021.
Jane, you mentioned the ACCC undertakes market studies. What have been the highlights in 2021?
So in my view, the most important ACCC inquiry is its review of digital platforms and big tech. To give some context, in December 2017, the Treasurer asked the ACCC to conduct an inquiry into digital platforms. The ACCC then released its report in July 2019, making 23 recommendations at the time, including advocating for changes to merger law and proactive investigation and monitoring of issues in these markets, including the establishment of a specialist digital platforms branch. The majority of these recommendations were accepted by government, and more recently, in February 2020, the Australian government directed the ACCC to conduct an inquiry into the supply of digital platform services, including a variety of related services like internet, search engines, social media, online private messaging, digital content aggregation, and electronic marketplace services, as well as digital advertising and data practices. This is known as the Digital Platforms Services Inquiry. And the ACCC is required to report to the government every 6 months for a period of 5 years, with a final report to be provided to the Treasurer by the 31st of March 2025. This inquiry is one of the most significant in ACCC history and requires the ACCC to report back on the intensity of competition in the markets for the supply of digital platform services, market trends and developments.
What's happened in 2021 in the Digital Platform Services Inquiry, now that the ACCC is around 18 months into the latest process?
The ACCC has done so much work in this space, particularly this year under the newly established Specialist Digital Platforms branch. It delivered its first interim report in September last year, 2020, where it looked in depth at online private messaging services in Australia and social media platforms and search. And it identified a number of competition and consumer issues, including noting that Google remains dominant in search and Facebook, which now owns both Instagram and WhatsApp, remains dominant in social media. The ACCC released its second interim report in March of 2021, and it found that Apple's App Store and Google's Play Store have market power in Australia and that this must be addressed. The ACCC concluded that app developers need fair and reasonable terms when dealing with app stores and fairer processes for the approval of apps to better address the consequences of each and of Apple's and Google's power in the app market. So on the back of this report, the ACCC has called for ex-ante regulation of app stores. And on the 19th of August 2021, Chairman Rod Sims delivered a speech to the Global Competition Review webinar on the ACCC's latest reports on app marketplaces. And Sims called for a strong and coherent response to tackle the dominant position of digital platforms in app marketplaces, and said that new rules and regulations may be needed, in addition to enforcement actions by international competition regulators to rectify these serious competition concerns about the dominance of digital platform giants like Google and Apple in app marketplaces. So the ACCC and international competition law regulators in the USA, in Europe, the UK and Asia have each launched inquiries and enforcement action and litigation to address these issues, but Sims at the ACCC fears that these measures are not enough, and he has observed at the ACCC a number of common issues in digital markets, including dominance of one or two market players, vertical integration, access to data, which the ACCC has found can entrench a strong market position and create barriers to entry and expansion. And they're also characterised by a lack of transparency in the market. So Sims said that although the ACCC has been successful in taking enforcement action against digital platforms in some cases, he believes that the regulatory toolkit needs strengthening and that enforcement action and market studies are not enough on their own. So Chairman Sims has called for international alignment to address the impact of the dominant digital platforms, and he's been bemoaning the fact that enforcement action is too narrow in scope, it takes too long, the damage is often already done by the time these issues are resolved in the courts. And he said that there's now a growing recognition of the need to regulate digital platforms to prevent anti-competitive conduct or harmful conduct before it arises. So the ACCC is following closely the actions of overseas governments and regulators that are aiming to address these competition and consumer concerns. And Sims has explained that although there's a lot of work to do in many jurisdictions to address the impact of dominant digital platforms, he said that we need to have an alignment in the international approach, as well as enforcement and merger control to achieve successful global outcomes.
Some pretty powerful words from the ACCC chairman. What are the next steps in the digital platforms inquiry?
So the next step is that in September 2021, the ACCC will release its report on its examination of web browsers and general search services and choice screens. And then next year in March 2022, it's due to release its report on the provision of general online retail marketplaces. So companies such as Amazon, MyDeal, Catch and eBay. And the ACCC has already released an issues paper on general online marketplaces and is now seeking submissions from consumers and businesses. The ACCC says that it will examine these online marketplaces and their relationships with consumers and third-party sellers and how they affect competition in Australian markets. And specifically, it will consider pricing practices, terms and conditions imposed on third-party sellers and the use of data.
Sounds like an extremely extensive review, which is likely to impact the majority of businesses in Australia, not to mention the consumers. What's been the response to these issues globally, and how's the ACCC placed amongst global regulators on this front?
So the ACCC has been observed internationally as a vanguard and an activist regulator, and a great example of this was its position as an early mover in relation to the conflict between news providers and digital platforms. Just to provide some background, in April 2020, the Australian government asked the ACCC to develop a mandatory code to address bargaining power imbalances between Australian news media businesses and digital platforms, specifically Google and Facebook. And a draft code was released in July 2020 and gained an enormous amount of media and political attention here in Australia, but also globally. And after months of review and consultation, the final legislation was passed by both Houses of Parliament in Australia in February 2021, and it's called the News, Media and Digital Platforms Mandatory Bargaining Code, and it's been a groundbreaking development in this area. It's resulted in Google and Facebook negotiating with news providers for news content, and if such negotiations fail, the parties need to arbitrate. Interestingly, although the legislation has been enacted, the Treasurer has not yet designated Facebook or Google or any services they provide for the purposes of the code. And it seems that the prospect of such designation has caused Facebook and Google to negotiate with the news providers. If the Treasurer does happen to proceed to designate either organisation, it will be interesting to see what happens. In terms of the global context, other jurisdictions are now implementing broader competition law reforms to address the gatekeeper or strategic market power of major digital platforms, especially as they relate to app markets, including in the US, there are a few antitrust bills targeting major digital platforms and a new bill on app marketplaces. The European Commission has the draft Digital Markets Act in Germany. There's the new competition legislation for digital firms. In the UK, there's a proposal to apply new rules to digital firms with strategic market status. And in Japan, there's the Transparency and Fairness Act, which came into effect in February this year. And in South Korea, there's draft legislation targeting app marketplaces.
It'll be so interesting to see what comes of the ACCC's review into digital platforms. And it's something all law firms and in-house counsel should be aware of, given that almost every business now has some sort of online presence and is likely to be dealing with or competing against digital platform operators, online marketplaces, ad tech firms, and app stores. It also cuts across so many areas of regulation, including not only competition and consumer, but also data and privacy issues. Can we now turn to some of those cases you mentioned earlier? You said that the ACCC has commenced a case against New South Wales Ports. Have they been successful?
Yes, so judgment was handed down in the case of New South Wales courts in June 2021, with the federal court dismissing the ACCC's case. The ACCC has already lodged an appeal against the federal court's decision, saying it will seriously hinder and prevent the Port of Newcastle from developing a competing container terminal for 50 years, which is a significant concern for the Australian economy. The ACCC claims the court erred in its decision when it said that a privatisation agreement that allowed the continuation of a monopoly was not anti-competitive. And this is the first time there has been a contested judgment in relation to the reformed Section 46 misuse of market power provision under the Competition and Consumer Act, which now allows for not only a purpose test, but also an effects test. And that was introduced by the Harper Review a few years ago. And so all competition lawyers will be watching this case with interest.
I see. The other first case you mentioned was about cartel conduct, and I understand that the first contested cartel case involving a jury has now been heard. Can you tell us more?
Sure. Following a lengthy trial at the start of 2021, a federal court jury acquitted Country Care, its CEO, Robert Hogan, a former employee, Cameron Harrison, of 8 criminal cartel offences. Now, Country Care is a rehabilitation aids company that supplies rehabilitative and assistive technology products such as walking frames to veterans and to the general public. This was the first contested criminal prosecution under the cartel provisions of the Competition and Consumer Act, and the first case ever to proceed to trial by jury. The criminal cartel charges related to alleged attempts to engage in price fixing and big rigging in the supply of these products, which are used to assist people with disabilities and are used in rehabilitation and aged care centres. And criminal proceedings were commenced by the Commonwealth Director of Public Prosecutions, or the CDPP, in 2018 after the ACCC conducted an investigation into the offences which allegedly occurred between May 2014 and May 2016. The ACCC was concerned that the alleged conduct would increase prices paid by consumers for products that are essential for the health and well-being and dignity of people, and it also had the potential to increase prices paid by governments for these essential products. Unfortunately, there's no judgment in this case other than a series of interlocutory judgments on procedural and evidentiary questions. And so it is difficult to assess the implications of the country care case for other criminal prosecutions in respect of cartel conduct, including, for example, the case brought against some of the major banks and bank officers, which is presently set down for hearing in 2022 with an estimated duration of up to 6 months.
So what's the key takeaway?
These proceedings and the ACCC's ongoing pursuit of criminal convictions in relation to cartel conduct are a reminder that businesses need to ensure their employees are fully aware of the risks of dealings with competitors, including potential criminal sanctions against individuals such as fines and imprisonment for cartel conduct. However, without reading too much into the outcome of the country care case, it's a reminder that contested criminal cartel cases, which obviously have very serious potential ramifications, are strongly contested and challenging for the prosecution to win.
In terms of global competition law litigation, how are Australian courts involved? We heard earlier that the ACCC chair, Sims, is pushing for a global approach to competition law litigation. Are we seeing that yet?
There's definitely some interesting private global competition law litigation at the moment, particularly involving Epic against app platforms Apple and Google. So Epic is the developer of the online game Fortnite, and it instituted proceedings against Apple in November 2020 in Australia. And Epic claims that Apple has contravened Part 4 of the CCA in relation to its App Store, and in particular by requiring that app developers, such as Epic, distribute their products through the App Store and its in-app payment system, and also by imposing an obligation on developers to pay a commission to Apple, which is typically 30% of the value of any sales. So Epic is alleging that Apple has breached Section 46 for misuse of market power, Section 47 for exclusive dealing, and also Section 45 for anti-competitive agreements that substantially lessen competition. In addition to that, it has brought a claim under Section 21 of the Australian Consumer Law for allegations of unconscionable conduct. The actual substantive proceedings haven't really started yet, and the debate so far has been centred around whether the proceedings should be allowed to continue in Australia at all. And that is because Epic signed up to a developer agreement which contained an exclusive jurisdiction clause in favour of the courts of the Northern District of California. And there's a well-established principle of private international law such that a clause should be respected unless there are strong reasons to depart from it. And Epic says that it should be allowed to pursue its claims under the CCA in Australia. And in April 2021, Justice Perham of the Federal Court granted a stay of the proceedings in favour of Epic's suit against Apple in California. The evidence suggested that the claims under the CCA could be brought in California, and Justice Perham held, with some hesitation that was expressed in the judgment, that the ability to pursue those claims in the federal court did not give rise to a strong reason which would permit the court to depart from the usual result of ordering a stay so as to enforce the exclusive jurisdiction clause. In July 2021, the full Federal Court of Australia, Justices Middleton, Jago and Mashinsky, held that APIC could recommence and continue its Australian legal proceedings against Apple, overturning the earlier decision by the Federal Court to stay the proceedings. The full Federal Court concluded that the ability to pursue these claims in the Federal Court did amount to a strong reason, having regard to the significant implications of any judgment for the Australian public. The ACCC supported EPIC's appeal, intervening as a non-party to provide the written submissions to the court regarding the application of competition law to app stores and the public interest in having this matter heard in Australia. So Apple filed an application for special leave to appeal to the High Court on the 6th of August 2021. So we haven't heard the last of this interesting case. And I think the key takeaway here is that it's the full Federal Court's view that it has jurisdiction to hear competition and consumer law claims that affect Australian consumers, even where there is a contractual exclusive jurisdiction clause stating that competition and consumer disputes should be heard in another jurisdiction, in this case, the USA. So for this reason, businesses should be mindful when they're contracting with global businesses that exclusive jurisdiction clauses may not be enforceable in circumstances where there may be a claim for breach of Australia's competition and perhaps even its consumer laws, at least where it can be suggested that the litigation has significant implications for the public.
I see. A lot of what we've been discussing has involved big business. What about the underdogs and small businesses? Any developments there?
Yes, so the ACCC has granted a class exemption to allow for collective negotiation by small businesses. And the exemption applies to businesses and independent contractors who form or are members of a bargaining group and who each had an annual turnover of under 10 million in the financial year before the group was formed. And this covers an astonishing 98% of Australian businesses. So small businesses and farmers can now collectively bargain with their suppliers and processors. Franchisees can collectively negotiate with franchisors, and fuel retailers can bargain with fuel wholesalers. And this is all without the need to ask or seek ACCC approval. And while collective bargaining by small businesses generally does not harm competition, when competitors act together, they need some form of exemption to avoid breaching competition laws. And previously, these exemptions were only available on a case-by-case basis through the ACCC's authorisation or notification processes. But with this new class exemption, most small businesses will no longer need to use those processes. And then this new class exemption process is quicker, easier and cheaper, allowing businesses to obtain protection simply by providing the ACCC with a one-page notice. And the ACCC Deputy Chair, Mick Keogh, said that the exemption will help businesses by allowing them to share the time and cost of negotiating contracts and will give them more say in negotiations.
Finally, what's happening with mergers? We know that the ACCC has long been advocating for further merger reform. What's the latest?
Yes, so the ACCC has been advocating for merger reform for a few years now, especially in the context of big tech companies. For example, in his speech to the Global Competition Review in August this year, Chairman Sims mentioned that competition agencies have concerns about big tech companies having the ability to entrench their market power through acquisitions, and said this was obvious in the case of Google and Facebook, who have made over 430 acquisitions worth more than 150 billion over recent years, and that this must be part of a core strategy to gain and entrench market power. So change has been on the horizon for a while. Very recently, on the 27th of August 2021, Sims delivered his address to the Law Council of Australia's Competition and Consumer Workshop and said that effective merger control is essential to ensuring markets remain competitive. And Sims again bemoaned Australia's current merger regime, labelling it out of step with most merger regimes internationally, under which mergers are required to be notified as part of a formal assessment regime and must obtain clearance before they proceed. And he backed his claims by referring to evidence which suggests that many markets in Australia are dominated by only a few suppliers, and expressed concern that without action, market power will become further entrenched and consumers will continue to pay more than they should for a wide range of goods and services. Interestingly, Sims specifically named industries characterised as having market power, and including banking, supermarkets, mobile telecommunications, internet service provision, energy retailing, gas supply, transport, insurance, pathology services, domestic air travel, internet search, and social networking services. So a lot of industries are under the microscope there. Sims identified 4 main areas of merger control requiring reform in Australia, including the process of merger control, the legal test and merger factors, the existence of market power in many markets, and acquisitions by large digital platforms. Sims cited numerous failings within Australia's current system of merger control, including challenges associated with the ACCC having to bear the onus of proof that future anti-competitive effects are likely, and the court's reluctance to focus on structural conditions for competition, as well as the fact that the Australian merger control regime is voluntary and non-suspensory, which the ACCC says has proved difficult for it when trying to obtain sufficient information from merger parties. And it also says that the merger control regime doesn't currently capture acquisitions in relation to digital platforms, which may enable these operators to leverage existing dominance or control data into market power in related markets. Sims summarised the ACCC's proposed merger reforms as covering 3 main areas, and I'll talk to them briefly. The first is a new formal merger regime, where there's one formal merger process where all acquisitions above certain thresholds are required to be notified to the ACCC, and the merger is prohibited until clearance is granted. The proposals would also allow only a very limited merits review to the Australian Competition Tribunal. The second area is a proposed reform of the mergers test. The ACCC would like the merger factors to focus more on the structural conditions for competition that are changed by the merger, in an attempt to ensure that merger analysis is forward-looking by including a definition of likely in section 50 of the CCA, as well as including a provision that takes account of market power and adding a provision for consideration of other agreements during merger assessments. And the third area for reform is to cover acquisitions by large digital platforms. The ACCC is calling for a tailored test for acquisitions by certain digital platforms to allow the ACCC to scrutinise and, if necessary, block certain critical acquisitions by large digital platforms. The digital firms that are proposed to be subject to this additional test will be determined by looking at the size and scope of the firm's services, whether it is a gateway in the sense that it's able to control how other businesses interact with consumers, and finally, the firm's market power. The nature of the test that the ACCC proposes should apply to acquisitions by digital platforms has not yet been determined by the ACCC. However, it is likely to be lower than the test applicable to mergers in the economy more broadly. So it remains to be seen whether the ACCC's proposals will be progressed by Treasury and then the government. But even at this early stage, the ACCC's proposals have already sparked debate amongst the competition law community, and the reforms have been called dramatic, and some experts are calling for extensive consultation to ensure there's no regulatory overreach, which could be detrimental to desirable industry consolidation. Other experts have labelled the proposals a revolution of the approach to mergers in Australia, being the most sweeping changes ever proposed to the merger competition test and the ACCC's clearance regime. It will be critical that the ACCC's proposals are robustly tested to ensure that the right balance is met between regulatory intervention and market dynamics. And so the key takeaway from all of this in relation to the ACCC's merger reforms is that all businesses, especially those operating in industries identified by the ACCC as being characterised by market power, should be aware of the ACCC's proposed changes to Australia's competition law merger regime. While the ACCC's reforms have not yet been adopted by Treasury or government, interested parties should ensure they are part of the debate, given the significant impact that merger law reforms would have on future M&A activity. This is particularly the case given the ACCC is proposing to suspend merger activity while the ACCC reviews clearance applications, as well as the lower standard of proof that would apply, so that a merger could breach competition laws if there was a possibility that is not remote that a proposed transaction would substantially lessen competition. So I know that's a lot to take in, but I think that it's clear that there's a lot going on in the competition law space in Australia, and we're only 3/4 of the way through the year. Before I go, I wanted to make a quick shout out to Tom Bridges, partner at Webb Henderson, and he's the general advisor for our practical guidance competition module. He specialises in competition and consumer law, particularly litigious matters. And I wanted to thank Tom for his input in producing this podcast, first in what we hope will be a series of updates on competition law issues in Australia. Thanks also to my co-host Julia for directing the conversation across the various topics.
Great. That wraps up our talk on Australia's competition laws in 2021, a year in review. Thanks very much, Jen, for all those useful insights, and thanks everyone for listening. You can read more about competition law and latest legal updates in our Practical Guidance competition module.